Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Hello viewers, you all know that Livelaw is a subscription-driven media house. We run our organization with affordable subscriptions and minimal ads from educational institutions. Readers and viewers like you are our strength. In these days of Diwali, we have further reduced our subscription rates and we request you to subscribe so that we can bring you more and more legal and unbiased content. Visit livelaw.in today and grab up to 55% discount on Livelaw premium subscriptions. Starting with an update from the Supreme Court, which has issued notice to the Himachal Pradesh High Court Bar Association regarding the members of the Bar Association abstaining from work on account of an advocate's death. A letter was addressed by the Registrar General of the Himachal Pradesh High Court at Shimla to the Supreme Court Secretary General regarding abstention of court work by a bar association. One of the lawyers had passed away and on that account, abstention was done on 9th September. The Apex Court has thus issued notice to the Secretary of the Himachal Pradesh High Court Bar Association. This is not the first time that the Apex Court has forced striking lawyers back to work or taken critical notice of their abstention. There are several such instances of the judiciary expressing exasperation with lawyers' strikes. Last year, the court monitored the strike at Sambalpur in Odisha over the demand for a permanent bench in the Western District and issued strictures. More recently, notice was issued to the Rajasthan High Court Bar Association at Jaipur bench over non-appearance of advocates due to a strike. The Supreme Court has significantly reiterated that a certificate under Section 65B of the Indian Evidence Act to prove electronic evidence can be produced at any stage of the trial. A bench comprising Justices Vikram Nath and Rajesh Bindal was dealing with the case related to the bomb blasts which took place in Bangalore in July 2008, which claimed the life of one woman and left many injured. During the investigation, certain electronic evidence such as one laptop, one external hard disk, 3 pen drives, 5 floppies, 3 mobile phones, etc. were seized at the instance of one of the accused. These were sent to the Central Forensic Sciences Laboratory, that is CFSL Hyderabad, which prepared a report after examination in 2010. The trial court in 2017 refused to accept the CFSL report, citing absence of Section 65B certificate. The prosecution stated that the certificate was not necessary as the original devices themselves were produced as the primary evidence. Still, as a matter of abundant caution, the prosecution sought to recall the Assistant Government Examiner CFSL to produce the certificate. In 2018, the trial court rejected this recall application and the High Court later upheld the rejection. But the Supreme Court has disapproved of the approach taken by the trial court and the High Court. The court pointed out that CFSL report was on record since 2012 and the necessity of the certificate arose only after the objection was taken by the defense when the examination happened in 2017. The court said that fair trial in a criminal case does not mean that it should be fair to one of the parties. Rather, the object is that no guilty should go scot-free and no innocent should be punished. And that by permitting the prosecution to produce the certificate at this stage would not result in any irreversible prejudice to the accused, as the accused will have full opportunity to rebut the evidence led by the prosecution. In another update, a plea has been filed in the Supreme Court by the Kerala government against the judgment of the High Court that had dismissed a PIL filed by a lawyer challenging action of the Governor of Kerala, Arif Mohammed Khan, withholding bills passed by the state legislature indefinitely. In the plea before the High Court, the state of Kerala was a respondent. The High Court had observed that it cannot fix a time limit for the governor to give assent to bills. Now, the state government has moved the Supreme Court challenging the same. You already know that Government of Kerala last week approached the Supreme Court with a writ petition under Article 32 against the governor for the same reason. The Supreme Court is set to hear this petition along with similar petitions filed by state of Tamil Nadu and Punjab this Friday. Stay tuned. In another update, the Delhi High Court today dismissed a petition challenging an order issued by the Delhi government in October 2021 prohibiting celebration of Chhath Puja in public places, public grounds, river banks and temples in view of COVID-19. As per the impugned order, the celebration was only allowed on designated sites with the clarification that no such site shall be designated on the banks of Yamuna river. The plea, which was moved by two societies, namely Chhath Puja Sangharsh Samiti and Purvanchal Jagriti Manch, argued that the order was illegal and arbitrary and had affected around 30 to 40 lakhs of devotees. They contended that Chhath Puja, being a religious festival and practice, such prohibition falls under the infringement of constitutional rights. But Justice Subramaniam Prasad refused to entertain the petition, observing that the prohibition had been imposed in order to prevent pollution in the river. The counsel appearing for the petitioners then withdrew the plea. The District Consumer Disputes Redressal Commission at Mandi district of Himachal Pradesh bench has held TATA Motors Limited and its authorized dealer responsible for failing to provide the car with the advertised mileage to the complainant. The background here is that the complainant purchased a Tata Tiago from the dealer. He was led to believe by the sales representatives that the vehicle would achieve a fuel efficiency of 23.84 kilometers per liter. However, upon purchasing the car, he discovered that the actual mileage was only between 12 to 15 kilometers per liter. Furthermore, the car exhibited various defects, including water ingress through the doors. The complainant contacted Tata Motors Limited, the manufacturer, and was assured that the defects would be resolved after the first servicing. However, the defects persisted even after the car was serviced. As a result, he filed a consumer complaint. The dealer argued that the vehicle's fuel efficiency depended on various factors. Further, they also presented evidence suggesting that a test drive conducted by the chief manager disproved the allegations. On the other hand, the manufacturer did not appear before the district commission, thus the matter was proceeded against them ex parte. The district commission acknowledged that the complainant was indeed misled by the manufacturer and the car dealer due to the advertisements and assurances made regarding the car's fuel efficiency. The commission held both the manufacturer and the dealer accountable for engaging in unfair trade practices and directed them to refund 5,23,000 to the complainant and pay him compensation amounting to 20,000 and also to cover the litigation cost. The Court of Additional Sessions Judge at Lal Bagh, West Bengal has sentenced 4 accused in the age group of 20 to 24 years to rigorous imprisonment till the remainder of their natural lives upon finding them guilty of gang raping and blackmailing a 16-year-old girl on Durga Puja 2 years ago. The incident had occurred when the child was visiting her maternal uncle's home in Murshidabad to attend Durga Puja festivities when one of the accused, Basu, called her out of the house, took her to a deserted place with 3 of his friends and raped her. The victim had actually befriended Basu on Facebook and he used to regularly call her, and she had developed a friendly relationship with him. The prosecution submitted that Basu involved his friends who took turns to rape her and also made a video of the act. The men subsequently threatened the girl with leaking the video in case she revealed the details of the sexual assault with anyone else. They eventually did leak the video. Though she had remained silent about her ordeal initially, but finally broke down and revealed details of the incident to her mother, who filed an FIR. Various independent witnesses who were examined, including the doctor who had examined the girl, delivered accounts of evidence which corroborated with her story. In producing all evidence, including the obscene video which was extracted from a mobile phone belonging to the accused, the court found that all 4 of them were guilty of the offences under the POCSO Act as well as gang rape under the IPC. The defence attempted to ask for lenient sentences due to the accused's tender age being young men who had recently embraced adulthood and were the only support for their families. But the court awarded them sentences for the remainder of their natural lives. And lastly, the Allahabad High Court has observed that to implicate an accused under the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989, what is necessary is that the offended words must have been used against the victim with intention to humiliate the person because of him belonging to SC/ST community. The court was dealing with a criminal appeal filed by Seema Bhardwaj, the accused appellant in the case, challenging the cognizance order of the Special Judge SC/ST Act in a case lodged against her over the allegations that she abused, hurled caste-based words and thrashed the victim who was working as house help for the mother of the accused appellant. The victim, on the other hand, alleged that the appellant accused used to quarrel with her mother and administer her wrong medicines forcibly, and she wanted the victim to leave the job so that she could execute her plans to take over the property of the mother. That the accused appellant had sent 5 to 6 unknown persons who stopped the victim and her mother on the road and hurled wild abuses and caste-based words against them, and also gave them a threat to not work in the house of the mother of the accused. Before the court, the appellant accused contended that as per the allegations in the FIR, she was not present on the spot at the time of the incident, and therefore whatever incident took place, which is said to have been committed by the 5-6 unknown persons, she could not be held responsible for the same. Taking note of the facts of the case, the court observed that at the time of the incident, the appellant accused was not present on the spot, and therefore her absence on the spot, cognizance under SC/ST Act, could not be taken against her. The court also read the FIR to note that the motive behind the incident was that the appellant did not want the victim to work as a house help in her mother's house, and hence the incident did not take place because the victim belonged to SC/ST community. Thus, the cognizance order was set aside. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.